Hello and welcome to our video on EHR payment reductions, also known as the Medicare Promoting Interoperability Program. So in this video, we're going to be covering a variety of aspects on this topic. First of all, we will talk about the EHR payments and the reduction timeframes. So this will cover the incentive payments, the original incentive payments, as well as these payment reductions and how the time frames fall into both categories and how they overlap. Then we will be covering an overview of the acute care EHR payment reductions, an overview of the critical access hospital EHR payment reductions, and then we'll talk about how to determine whether an acute or a critical access hospital is subject to the reduction. We'll talk about where to find more information on the attestation process and the hardship exceptions. And finally, we will go through some cost reporting information to show how this is ultimately reported. So first of all, we will talk about the original EHR incentive payments, also known as high-tech or HIT payments. These were effective for cost report periods beginning in federal fiscal year 2011 all the way through cost report periods beginning either through fiscal year 2015 for critical access hospitals or through fiscal year 2016 for acute care hospitals. So at most, this allowed for a 6-year period, a 6-year range of time in which different providers could qualify for the EHR incentives, but it's important to remember that no provider could ever receive more than 4 years of payments. And furthermore, once the years started, so once they hit their first year of EHR incentive payment, the years continue consecutively, whether or not they actually qualify for one of those interim years or not. So at most, a provider could get 4 years, even though for acute care hospitals they had 6 years to choose from. Now, these incentive payments were available for any provider that attested to meaningful use of electronic health record technology. Now, these incentive payments and the reductions that we'll talk about, they were enacted into legislation through the Recovery Act, the American Recovery and Investment Act of 2009. Now, that act also included these payment reductions that is really the main topic of this video. The idea here was that for the first few years, there was an incentive for providers to attest to meaningful use, to basically to become meaningful users of the electronic health record technology. However, at some point, the incentives stopped based on the timeframes we just talked about, and now there's a payment reduction for those facilities that had not yet attested to meaningful use by federal fiscal year 2015. Now, furthermore, this is an ongoing type of thing, so technically a provider could have qualified for meaningful use incentive payments early on, but if they failed to meet the criteria going forward for whatever reason, then they may also be subject to reductions in these later years. Now, the other thing I want to mention is originally this was referred to as either the EHR incentive payment, the HIT payment, the high-tech payment. There are a variety of names for it. Now the terminology is Medicare Promoting Interoperability Program. That's the term for basically the reduction side of things. This is, as we discussed, it's legislative, it's in law, it's been enacted into law, and until Congress decides to remove this, these payment reductions will continue to apply. But there is a difference in how they apply, how they impact an acute care hospital versus a critical access hospital. No other provider type, by the way, other than those two types of hospitals, is impacted by these payment reductions. No other hospital was impacted by the incentive, and no other hospital type will be impacted by the payment reduction side either. For an acute care hospital, the payment reduction reduces the annual market basket update factor that is used to determine your DRG payments, your PPS, prospective payment system. The DRG is diagnostic related groupings. So every year, as part of the federal rate, it's updated from year to year based on an inflation type factor, a market basket update factor, so that in one year you're going to generally get more for that same type of claim than you would in the prior year. What happens here, though, is for a provider that has not yet attested to meaningful use for this year, you're not going to get the full inflation factor, the full market basket update factor. It's going to be reduced anywhere from 25% to 75% of the reduction factor. Now, that means there will still be some sort of increase, some sort of inflation factor, but it won't be the full inflation factor. Obviously, that will impact your payment. The other important thing to understand is this is not cost report related. It's on a claim by claim basis, on a federal fiscal year basis. So what that means is this payment reduction is going to take effect 10/1 of that particular year in question, regardless of what type of cost reporting period you have. And furthermore, it's not going to require a change in how you report your costs or DRGs or anything like that on the cost report. Of course, with the claim by claim, that's going to impact how the claims show up on the PSNR, which you use to fill out your cost report. So certainly the numbers will be different, but it's not, you're going to pull the numbers from the PSNR anyways, so it's not something as you're filling out your cost report that you really need to be all that aware of, except for the control lines, which we'll talk about at the very end of this slideshow. Basically your S-2 line 167. It's really informational only for an acute care hospital, but it should still be correct. So what happens here is if something changes for your status, so if we find out, if CMS notifies us that, hey, this particular provider is subject to this reduction, then hopefully we know ahead of time. For most providers, we'll know ahead of time because it's in the Federal Register and it shows yes or no, were they subject to the reduction. That way the claims will process correctly right at 10/1. But in some situations, something changes, and we'll see this in the next slide. Something changes from what was in the Federal Register, where either a provider failed an audit. Let's say, yes, they attested to meaningful use, but maybe that status is audited later on, and it's determined that the attestation was wrong. The provider really did not meet the requirements. In that situation, we would have to do a recoupment, a reprocessing of claims to basically recoup that extra money that the provider should not have received. In other words, they should have been subject to the payment reduction effective 10/1, but it wasn't known at the time. So it could go that way, or it could go the other way where perhaps a provider appeals their status, or they have submitted a hardship exception, which removes that subjection to the payment reduction. So in those situations, that could happen again mid-year after 10/1, and we would do a claims reprocessing at that point to correct to the higher rate, to basically reestablish the full market basket update. So one way or the other, this does require reprocessing of claims if it takes effect after 10/1. But there is no cost report reconciliation. That's the key thing there. The other point I want to make here is that this has a 2-year delayed impact on the reduction. So a hospital that failed to attest in federal fiscal year 2017 is going to receive this reduction. They're going to see the impact of this reduction for their claims in federal fiscal year 19, regardless of their status in 2019. So it's a 2-year delay, and at that point you're going to receive the reduction in fiscal year 19, even if you're a meaningful user in 2019. That has nothing to do with it. It was based on your status 2 years ago. Now, the critical access side of things is different because it is cost report based. The payment reduction for a critical access hospital reduces the percentage of cost reimbursement they receive on their cost report. because that's how critical access hospitals are paid for the majority of their services. It's based on cost. Usually it's based on 101% of that reasonable cost. But for a critical access hospital that is not attested to meaningful use, they are reduced down to potentially 100%, depending on the year in question. So it could potentially impact 1% of their total cost, basically reimbursement there. Now, this is reconciled through the cost report. There is nothing claims related for the critical access hospital. Therefore, it's going to require an adjustment at the time of the final settlement or the reopening. If it's already been settled, we may have to do a reopening. Now, this application period is a little bit different as well, because this is based on the meaningful use attestation status for the federal fiscal year, in other words, 10/1 through 9/30, in which the cost reporting period began. So a critical access hospital that fails to attest for meaningful use in federal fiscal year 2017, which is basically 10/1/16 through 9/30/17, they'd see the reduction in the cost reporting period that began in that same federal fiscal year. Now, obviously, unless they are a 9/30 provider, it's not going to be a perfect overlap. Let's say you have a 12/31/17 cost report, and in this case, if you failed to attest to meaningful use in your federal fiscal year 17, then your 1/1/17 through 12/31/17 cost report would be impacted. If you had a 6/30 provider, 6/30/18 would be impacted because that's 7/1/17. It began in this range, 7/1/17 through 9/30/18. That would be the year that's impacted by this meaningful use payment reduction in that case. So that's the thing to note about that. Now let's talk about how a facility knows whether they're subject to that reduction. For the acute care hospitals, as I said, it's all based on the federal fiscal year. It's all claims related. So you can actually see this on each year's proposed or final rule on the CMS website. All of the various files that come out of that rule, out of that Federal Register, are stored on this website. So here I've just taken a screenshot. You can see the Federal Fiscal Year 2021 IPPS Final Rule homepage, and I have the little arrow pointing to the impact file specifically for the Fiscal Year 2021 Final Rule and Correction Notice. So that's important to notice. It's always the impact file. You can see up here, 2021 IPPS Final Rule homepage. There's one for the current proposed rule as well. But once you click on the inpatient or the impact file, then you're going to see a spreadsheet, and it's the impact file itself. Toward the very end, if you scroll all the way to the right, it's the second column from the right. There's going to be a column labeled Proxy EHR Reduction. Now, of course, you'd want to find your own provider number, and you'd look at that line, and here you'll either see a 0 or a 1. 0 means you are not subject to the payment reduction, which apparently means you had attested 2 years ago. You tested successfully. A 1, on the other hand, means that that provider for this federal fiscal year, 10/1 through 9/30, is going to be subject to the EHR payment reduction, barring any other change in the future. So, as I said, this is the information we get prior to 10/1, for the most part prior to 10/1. We can set our system up to show whether or not the provider is subject to the reduction or not. That'll impact the claims that come in effective 10/1. Now, as I said earlier, changes can be made to either add providers to the reduction list or to remove them from that reduction list. And we gave a few examples of how that could happen. There could be an audit of a provider's attestation, and they find that, no, the attestation was faulty for some reason. So even though this shows a 0, if that audit is done after the fact, it may very well mean this provider is added to this listing and now we have to reprocess claims. There could be an appeal of an attestation where you were denied up front, so you show one now, but maybe the appeal went through and you won the appeal. In that situation, you'd be removed from the reduction listing, the claims would be reprocessed, and you would receive your extra money back. Or in some cases, there might be a hardship exception where, yes, you did not attest, but you had a valid reason for it, and you were granted an approval for a hardship exception. So those are three main reasons why this listing can change. But keep in mind, this is what we know about up front. The other thing I do want to mention, I don't have a screenshot of it here, but CMS does send MACs reports on a fairly regular basis showing whether a provider has changed or not. It's basically a delta report showing whether or not there's an addition or a subtraction or a removal from the listing. Now, that's what causes us to go in and reprocess claims if any status has been revised. Now, for the critical access hospitals, it's completely different. There is nothing in the Federal Register. There's no listing of providers that are subject to the reduction or not. MACs do get a listing of providers from CMS, and we're required to send out letters annually. I've got an example of what that letter looks like. It basically just it talks about the background of the payment reduction, where it came from in the legislation, when it applies, and it says you're receiving this letter because our records indicate that the facility is a critical access hospital and did not successfully demonstrate meaningful use of certified EHR technology for whichever calendar year is in question. And then it goes on to say that because of this, the hospital received a reduced reimbursement amount of 100% of reasonable costs for this cost reporting period. There's a time frame for a payment hardship adjustment, and that's what that link down here is for. There's also an adjustment reconsideration form, but there's a due date for that each year. So if you've received this letter, that's preliminary, basically saying that you may be subject to this reduction and you need to either be ready for it or send in documentation to show that it's incorrect. Now, the other thing is that once we get this listing, those particular cost reports have to be put on a hold. So we cannot settle these cost reports until CMS generates the final listing. At that time, or between the time we get this listing and the final listing, the status may have changed. Again, there might have been a provider that submitted a reconsideration form. There may have been a provider that submitted a hardship request, or just the status may have changed for one or another reason. So because of that, by the time we get that final documentation, we'll use that to determine how to settle the cost report. And again, as I said, there might be a variety of reasons why this could change. Now, we have had situations where providers dispute the status that we have on our listings. So if it's an acute care hospital, they, again, may have had an appeal, they may have had a hardship, whatever the case may be, but we have the information from CMS, and that's the only thing we can go off of. So if a provider believes they have received an inappropriately applied reduction, so they've inappropriately been subjected to it or not when they should have, then contact us, and you can contact the Audit.Advisement at WPSIC.com website with whatever documentation you have to show that, yes, you did attest for the year in question, or you were approved for a hardship exception, anything like that. And we can submit that to CMS to have them review it and approve it. We can't take the documentation by itself and make a change. We have to forward it on to CMS to make sure nothing since then has happened, and we have to get their approval because it would dispute what they've already given us as a list. We have to get their final approval for any sort of change to the listing they've given us. Now again, either the cost report will be reopened if needed, if it's a critical access hospital, or if it's an acute care, the claim system will be revised and the claims will be reprocessed as applicable. This next slide here, it's another link to the CMS website, and it just provides information on attestation requirements and the incentive program, registration, things like that. So I know it's kind of a lengthy path. You could search for EHR incentive programs in the CMS website, and that should take you right there. The final slide I have here is the cost report itself, where to report information about your EHR status, your meaningful use status, and it really all boils down to worksheet S-2, lines 167 and 168.01. So in this case, line 167 simply asks, have you attested to meaningful use? It actually says, is this provider a meaningful user? But really what that means is, have you attested to meaningful use? That's a yes or no answer. And 168 no longer applies. 168 was for critical access hospitals to report the cost of the EHR assets they purchased. We're outside of those incentive payment periods at this point, so 168 is not applicable. 168.01, however, is still applicable. It asks, it's for critical access hospitals only, and specifically those that are not a meaningful user. It says, does the provider qualify for a hardship exception, yes or no? So the way this was initially developed, it's supposed to work right along with 167. So if you've already answered line 167 as yes, then really 168.01 just doesn't matter anymore. You could put yes there. You could put NA, or I'm sorry, you can't put NA. You can put yes, no, or blank. And really it won't matter because 167 trumps everything. If you have 167 answered as yes, then whatever you have in 168.01, it won't impact anything. However, if line 167 is no, which basically says this provider is not a meaningful user, if you have qualified for a hardship exception, then you can answer that as yes, 168.01, and it will basically be the same thing as if you answered 167 as yes by itself. It has the same impact. For acute care, it has no impact at all either way, but for critical access hospital, answering yes in either of these lines means that you're going to receive your full 101% of cost reimbursement. Answering no to line 167 and a non-yes answer to line 168.01 means that your cost reimbursement is going to be reduced down to 100% at this point in this year. So that's how that works. Now, the biggest problem with this, the way it was developed versus the way it works now, is that MACs no longer get specific information from CMS on which providers truly attested versus which providers just received a hardship exception. The only thing we receive is a listing of whether the provider should be subject to the reduction or not. So in many cases, unless we have other documentation, we focus solely on line 167, and we basically use that as a, should they be exempt from the exception? That's another way to read line 167. If it's answered yes, which means you either attested or you qualified for a hardship exception, then that essentially is saying yes, they should be exempt from the reduction. Now, if this is answered no, line 167 is answered no, then the reason we answered it that way, the reason we adjusted it that way, is that we have no information that shows that you do not need to be subject to the exception, to the reduction. So again, as long as one of those two lines, 167 or 168.01, is answered as a yes, then you're not subject to the exception. Now, if you have provider information that shows whether you had a hardship exception or whether you attested, and again, if that differs from what we have, what we've adjusted, please let us know, and we can forward that on to CMS and try to get a quick resolution. That takes us to the end of what I wanted to talk about for the EHR payment reductions. Hopefully this information has helped a little bit to clarify. But again, if you do have any questions on that payment reduction, please send them to this email address, the Audit.Advisement at WPSIC.com. Thank you for your time today.